All right, good afternoon, everybody. I want to welcome you on behalf of the Bernard and Audrey Rappaport Center for Human Rights and Justice at the Law School at the University of Texas at Austin. Karen Engel is very, very sorry that she can't be here today. She and our speaker apparently go back quite some time, but Karen is sick. So I'm going to try and do the impossible task of channeling her, or maybe I won't. We're very excited to welcome Dr. Amaya Alvez. We are piggybacking in this event on a conference that happened over spring break, a Global Constitution Summit, and we're very, very glad that Dr. Alvez was willing to stick around for a few days after that and speak to us. Before we get started, I want to thank the Teresa Lozana Long Institute of Latin American Studies, who's one of the co-sponsors of this event, and the Department of Government. And I especially want to thank Dan Brinks, who was the co-director of the Rappaport Center before me, and it's really great to have you back with us, and look forward to many more collaborations. After Dr. Alvez speaks, we have two respondents. Professor Rand Herschel, who is a professor of government here at the University of Texas, and the Earl E. Sheffield Regents Chair in Law. And I wonder if you've already met at the... Okay.
We have.
Yeah. All right, great.
More than one.
Okay. And then our second respondent is Guillermo Perez, who's also a Chilean lawyer and is doing a PhD in the Department of Government at the University of Texas. Okay, so let me introduce. I'm going to be brief because we want to hear you. Dr. Amaya Alvez is a professor of law at the University of Concepcion in Concepcion, Chile. She is a former member of the Chilean Constitutional Convention, where she developed a constitutional approach to the decentralization of the country. Alvez is an activist and a human rights defender, and is an active member of multiple organizations promoting environmental, women's, and indigenous rights. Her research focuses on constitutional law, human rights, water regulations, and indigenous peoples. The title of her talk today is up on the PowerPoint. And Amaya, the floor is all yours. Thank you.
Thank you. Thank you. Good afternoon. Many thanks for Karen for inviting me and for all of you to be here on a rainy day. So many thanks. So I will address water, ancestral knowledge, and the Chilean Constitution. I will do it in three parts. In the first part, I will address some debates on legal personhood of nature. It's a paper I already published. And we refer to some Latin American cases, judicial cases. The second part, I will address the field work we have been doing on the Keuka River, which is actually, in a way, the use of the first debate, more of a theoretical judicial debate. We put it in a field work on the Keuka River in Chile. And in the third part, I will address some of the work we did at the Chilean Constitutional Convention and a couple of provisions about the draft. First thing, so this paper on legal personhood of Latin American rivers, we asked if it was time to shift our constitutional paradigms. And we published it in 2021 in September. If you see the date, it was already the Constitutional Convention going on. So it got published, and we were having all these debates at the Constitutional Convention. And we compared three different countries from Latin America. So Ecuador, with the 2008 Constitution, already enshrined rights of nature and recognizes that nature can have legal personhood. And in this, what some author has called this biocentric turn in the constitutional paradigm, we also use a case from Colombia. I put the date of the Constitution is 1991, but the case is 2016. So it's not something that is in the Constitution drafted, but has been an interpretation done by the Constitutional Court of Colombia. And they call it biocultural rights. And it's a sort of a hybrid between human rights and rights of nature when rivers are recognized as entities with legal personhood, but then indigenous people or Afro-descendant communities are called the guardians of that river. So it's kind of in the middle, like a middle ground. And last and least, Chile is the 1980 constitution, which sees nature as a commodity. So nature is protected through private property from a very anthropocentric perspective. And we take a case on the Loa River, which is actually a river that has been already named as a dead river. Before I started to work with water and rivers, I didn't know that it was, from a river science perspective, a category in which you could talk about dead water and dead rivers. And actually the Loa is a dead river. So I need to disclose, I have some maps. It's not my doing. I will never, ever be able to do that. Some of my doctoral students, I need to say that because they are amazing and they bring so much to the table as river scientists. So, this is called, the first time I thought this was something we needed to take into account is when science, which is a very, very high-level journal, is something, we say this in Chile, if you got published in Science, you will be on a cerebral plate for a long, long time among your colleagues. So Science published in 2019 this paper called A Rights Revolution for Nature. And it was done by 2 law professors. So I thought this is something we should take into account because, Science, which is a leading journal, is already talking about something that could be relevant for law. So I go back, and then in this article, thinking about this right revolution for nature, we came up with the idea, reading cases, that a very good proxy for this could be rivers. Mainly because it's one of the natural elements that made so necessary the relationship between human beings and nature itself. The history of the life on Earth has been told through rivers, like Nilo and others, I guess. In Chile, for example, the Biobío River, where I live, it was the frontier between indigenous peoples and the conquerors. And I guess maybe the Rio Colorado has a lot of stories to tell as well. So we thought the paradigm of rights of nature could be seen through rivers. And actually, Latin American constitutionalism offers a way in which these various ideas could be addressed. And then I pose the question, if this legal pluralism, and if so, which different types of knowledge should be taken into account? So this is the publication of this debate. And these are the 3 case studies we did. So nearby, the Atrato Basin is that river up north in Colombia. The other is the Vilcabamba, which is in Ecuador. And finally, we took the Loa River, which is in northern Chile, as you can see, is in the middle of the desert. And the other 2 rivers are actually part, I will say, more of a forest Amazon configuration. And what we saw and what we came up in that paper, because part of the debate we had with other disciplines is to be able to take all that information about river science and river well-being and give it a legal structure, a constitutional structure. So if you talk about fundamental rights of rivers as legal entities, what will you say? And we came up with 3 categories. Throughout a whole of literature, there has been a lot published on this in the last 3 or 4 years. So we could talk about some rights related to integrity. And in Chile, the main difficulty in the last couple of years has been this idea, because water is a commodity, that you just can take water and put it wherever is needed. So, for example, they are talking about water highways. That you just take water. There was this plan being even like published, and then they were looking for investors when they took water out of the Keuco River, the river that I will show to you in a couple of minutes. They will bring it to the desert, I don't know, in order to help the Loa River. But it was a highway like maybe 3,000 kilometers long. And if you think of all the implications such a thing could have, but apparently for them was a great idea, because, I mean, you will bring water where water is very scarce. So because we were talking about the geomorphology of natural evolution, I mean, this rights to integrity might be relevant. The other set of rights we were talking in this paper is this idea of a healthy existence. And for example, we were talking about the impact that large reservoirs can have on water. I was walking the other day next to the Lady Bird Reservoir, and I thought it might need a little help of rights related to healthy existence. Because the problem with close, when you do not let kind of flow water, is that it become very affected by contamination or biochemical aspects of it. I mean, there's a lot to say. It's not my discipline, but I've learned a lot about it. And the other thing is this idea of biocultural diversity and interconnections in the system. And the idea that human beings are also part of nature. When I'm talking about rivers or legal personhood of nature, I'm thinking of human beings as part of it. I'm not thinking of this idea of separation. I'm thinking of this interdependent part that humans play in a fluvial ecosystem. And if you think this is like crazy ideas that no one is talking about, actually it's not the case. We see from 2000 on, we had so many cases only in three countries. So it's a global trend, we could say. I mean, there are also very interesting cases from India, from New Zealand, from various countries. But we just took Chile, Colombia, and Ecuador. So we took the leading cases, but we don't use precedents. That's interesting to say. But we see a trend coming up to 2020 when we wrote the paper, that there were many, many judicial cases coming before the courts in terms of claiming river rights. And this, I wanted to share with you as well that this has been a little bit of a challenge, because in order to understand all this, in order to be able to grasp the well-being of a river, of course, I needed to work with other people. And we were talking about river science, and we also were looking for information about indigenous knowledge, about the way in which the Mapuche, those who live in their ancestral land, see water. And for example, for them, it's the blood of Mother Earth, what they call Ñuque Mapu. And another thing that I found it was amazing is in Mapuche language called Mapu Sungun, there are around 50 words for water. So it's not water. I mean, we just say agua in Spanish. But for them, water will be a different name if it's the morning water, when you have some, I don't know, some, how will you call that? Bruma.
Bruma, or mist.
Mist. And in the afternoon, when the sun reflects itself in the water, it will have another name. And when it cannot flow, it will have another name, and depending on the plants, will have another name. And I was impressed because I was trying to learn Mapu Sungun. Of course, I failed, but then I realized how much harder it is when you get so many words for one meaning. And then I asked as well if it's possible to do an horizontal dialogue. And this idea of normative orders and then I found so many problems in academic terms to think of indigenous knowledge as an equal knowledge that can be used as a source compared to scientific knowledge. And then I think I brought an example. I hope it works. It helps for you. So now I'm taking the second part, which is the indigenous part. So in Chile, there are 11 indigenous and tribal peoples. If you see the dates, most of them were recognized in 1993 through the Indian Act, but some of them have been recognized afterwards. For example, the Diaguita through a case before the Inter-American Human Rights Court. The Changos only in 2020, so right before the Constitutional Convention. Even if the Afro-descendant tribal people were recognized in 2019, they didn't get a seat on the Constitutional Convention. I mean, that was a huge debate, but there are differences between tribal, Afro-descendant people and indigenous people. And if we think about it, which amount of the population self-recognize themselves as indigenous, is 12.8% of the total population. So it's a minority, but a relevant minority in Chile. And I was talking yesterday to some of the government PhD students, and I told them that I do think in order to grasp constitutional legal norms, constitutional frameworks, and the debate, we need to think about the colonial structure and how it was, what we had after as a state, as a constitution, was kind of put on a system that divided people into at least 27 castes. And from day one, they just declared formal equality. And I don't think we have been really addressing the system that was previously in place in order to make sense of what we see now. I mean, last year, the anti-indigenous movement, the anti-indigenous claims were, for me, impressive. And it is like you open up like a shut door, and then you say, why? We have never been able to see how deep these ethnic divisions were. And I think this is relevant. There were only 30,000 peninsulares, so people who were born in Spain, and 3 million criollos. And those are the two, let's say, social groups that will be in charge. There will be political subjects. There will be taking decisions when the state nation was formed in the 18th century. And all the rest were invisible. But all the rest are still invisible in a way now, because it's not in the 19th century. I mean, Indios, so indigenous people, have never, ever been recognized in Chile, although there are 12.7% part of the population, and they have been very relevant. And I'm trying to make the claim that from an indigenous perspective, you could do a better job in protecting nature and protecting river rights. They have never been recognized at a constitutional level. So I think this is relevant. Of course, we cannot devote much time to it, but I think we should take it into account. And then I do think indigenous people all over, but also am I talking too fast? That's all right. Perfect. Okay, because I'm not a native speaker. Sometimes they think, oh, everyone will understand. Sorry for my Spanglish. But no, this idea that, sometimes I do think we create these categories, this legal concept, like indigenous people, and you claim everyone will understand what is behind it. And I don't think it's right, because it's like when you say Latin America, and you can't grasp what is behind that, like the diversity, the claims are quite different. And I think we do the same with indigenous people, but at least I think Amar Bathia, which is a dear colleague, when he says that there is a common experience of colonialism, dispossession, and attempt at assimilation, I think it's right. This claim is general, but it's right. And I do think this reality put indigenous peoples in a condition of political subordination, economic exploitation, cultural devaluation. In some countries in Latin America, this has been partially reversed, in Bolivia and Ecuador, and maybe also in Brazil or in Colombia, not in Chile. But Luis Eslava and Sanja Payuja says that sometimes you need to use the legal system in place in order to be able to speak, interact, and act. And I do think that happened in Chile. Indigenous people have not been constitutionally recognized, that have been used in the legal system we have in place. So I brought an example. I hope it works. Sorry, I didn't have the time to put the slides in English, so it's not that I will require Spanish to see this, but I thought this was a very interesting example. When I asked students of mine in Chile, do you think indigenous people know something different from your scientific knowledge, or maybe they have discovered something that you have never thought about it? Most people will remain silent. They wouldn't know. They haven't thought about it. They haven't encountered this. And you know, this was a thesis at the University in Temuco from 2019. And the thesis was done by a Machi. A Machi is like a spiritual leader for the Mapuche people. And no one wanted to take this thesis like as a graduate student. And the dean finally took it, saying, okay, I will take the risks. And what this Machi says is, if you use that instrument called kultrun, which is an instrument that for indigenous peoples is used to repair and it's physical space, it could health, human, animals, and plants. And it could repair like territorial spaces. So this is the idea that this kultrun could be an ancestral instrument which intensity or frequency of sound could heal. That was but he was in a career related to, how do you say agronomia?
Agriculture.
Oh, great, for once. So the question is, will be the music of this kultrun have effective, so positive effects on the seeds and the growth of those seeds? Like most people will think, well, what are you doing this? I mean, why are you taking so many risks? And even people saying to the dean, are you really wanted to do this? I mean, this is serious work. And apparently he was able, through a scientific method, that was the thing, he did a scientific method. For example, this blind thing that you put some seeds that were kind of use the kultrun to heal them, and some others that don't, and it was blind. And they realized, and these are the differences, that those who were exposed to the kultrun had quite a different and bigger growth. And that was interesting because it was portrayed in Economy and Business from El Mercurio, which is the most far right-wing newspaper you can find in Chile. And it says, Machi studies the effect of kultrun in the growth of vegetables. So then people will say, okay, maybe now kultrun has become really kind of fancy instruments to make things grow. But I'm sure you know what is behind. And maybe this thesis poses a lot of questions to some agriculture students and their backgrounds. And then I was thinking, what could we learn from law students? What can we do? I mean, I was telling to Ran before this talk that far too long I have the impression that we as law professors have been living in this ivory tower. I'm sure political science professors and English and government professors are much better than us. But I think my colleagues and I, for sure, are part of that too. Too many times think that we are self-contained discipline, that if we just study law books and law legal norms, we will be all right. And I really don't think that way. And it's not the research I'm doing. So the second part, I'm doing a lot of, I'm not, Camila, which is in the water right there, is doing a lot of field work in the Keuko River. And she even got a grant from York University in Canada, and she set up like a whole bunch of information there, how her journey was. She moved to live with the Pehuenche for almost a year in doing research with them, and she tried to set up a dialogue between river science, she was from an agricultural background, with Mapuche science of rivers. And it has been a very interesting conversation, because the first things we find out is it's really hard to take the Western kind of broken system of everything has a different law. So the territory it's the urban thing, the territory, the river, and everything, it's kind of cut in different pieces. And for the Mapuche worldview, that doesn't make any sense. And she has been conducting a lot of interviews with local people. So, for example, they believe there are owners, like spirits of a place. And so, for example, for them was so difficult to understand why the legal system in Chile transformed water into a commodity. Because it's a commodity, something you can buy, and you don't need to use it, and you don't need to live in the place. So, for example, we come out, we were looking at who owns the water of the Queuco River, and she even made a map. I didn't put it here, but it's a very interesting map. That all the owners of the Queuco River lives in the capital, in Santiago, in a very wealthy neighborhoods, and they won't use it. Maybe they're waiting for the Queuco to get very kind of small, so the price for water will go higher, and that this is even a big problem for indigenous people who live nearby the river, and they cannot use it, and not a lot of water. And we have also, and I wanted to bring it because maybe it's interesting for you here, I think there are a lot of challenges for researchers when we go to indigenous ancestral lands, and at least in Chile, we have not work on protocols on this, and for example, in some indigenous communities, they don't want researchers to go anymore. They feel they have been used by researchers. They will tell you stories, yeah, that man came, or that professor came, she stayed with us, we were kind to them, she told us she will come back to give us feedback, and they never came back. Or they publish it in a language that we can't understand, or things like that. So we have been working on participatory research tools, and we have been trying to follow these principles: inclusivity, adaptation, sensitivity, and reciprocity. And I will need to tell you, it's not easy. Sometimes indigenous people are mad, and they're rightly so. They have encountered so many problems. They distrust. They are very skeptical, very, very, very. And so sometimes she was living there for almost a year, and she told me it was the hardest year of my life, because she needed to kind of build a relationship, but with people who have been hurt for so long. So it's not easy. But we are trying to set up some guidelines. And finally, I thought I will bring you all this topic back to what is happening right now in Chile, this idea of a constitutional moment, a constituent moment. This is a very kind of well-known picture. I think you have seen it before. I was in Brazil, and there was this big, big picture on a wall. And the guy says, yeah, it represents a lot even for us in Brazil. And I thought, oh, great. This was like during the protests in Chile in 2019, and this is a statue of one of the militaries of one of the wars in Chile. But what you see at the top is the indigenous flag, and the indigenous claims, demands were at the core of the October 2019 social uprising. And this is a sort of I would say, tension with what is happening right now. And when the convention started, it was a very, I would say, unique moment for so many, because Elisa Loncón, which was a Mapuche representative, was elected the head of the Constitutional Convention. And I told the other day, I was at this conference, I thought I will never see this in my entire lifetime, like a woman, a Mapuche leader, like running this Constitutional Convention. And they normally ask me if I have kind of a summary of my experience, and I just put some of them there. I see it as a failure, actually, for now. I mean, you said the other day that it depends on the time frame we look at, but for this short period of time, it was a failure. And I think it was a very hard task to fulfill, because most people didn't have political experience, because many of them were representing just particular interests. So they went there for water rights. And everything beside water rights wasn't interesting for them, or they didn't understood the Constitution as a whole. And I think there was a lot of expectations from people, from the media, and I do think, and the other day we were talking about this idea of full transparency, of bringing online everything that was debated, negotiation and persuasion. For some people were like giving up on some topics, and they didn't understand what people will compromise. Okay, among others. I can send you the PowerPoint if you think it's interesting. And this is another, I think one of the challenges as well was to understand that there are others on the table, even if you've never seen them or you never thought of them as relevant. So this is Isabella Mamani, and she was an Aymara representative, but she's a lawyer, and she spoke as a lawyer. And you can't even imagine the reaction of my fellow colleagues, because she was dressed like that, and she made amazing points. But this is I think it's ignorance, but at the same time it's distance from how the others can be, and how our standpoint affects our worldview. We were talking yesterday with Guillermo about how now it's a whole debate in Chile about who is drafting the Constitution. And they're mostly elites. They're mostly from Santiago, and then people feel why people feel not represented. And I think because you speak from the science standpoint you use in the world. Okay, and finally, I thought I might show you some of the constitutional provisions. I put some of them on the paper, but I think we could talk maybe after if you are more interested in others. For example, there's this idea that indigenous people and nations are holders of fundamental collective rights. It was the first time it came into the Constitution. Or the idea of nature as the holder of rights recognized in this Constitution and applicable to it. Of course, not all rights are applicable. There were some traditional uses of water that were recognized in Section 58. There was the right of indigenous people and nation to preserve, revitalize, develop, and transmit tradition and ancestral knowledge. That was something, because it's the first time we talk about the idea of ancestral knowledge as such as one category. This was taken, of course, from the Ecuadorian Constitution, but it was the first time someone talked about it. Well, the very idea of nature as bearers of rights, and okay. So Latin America, I told Ran, I felt it was presumptuous to say ahead of the game, so I put a question mark. Because I think we really would like to be ahead of the game for once. And but then after the last year's experience, I would say, I'm not sure anymore. I wouldn't say the same maybe a year ago. Can we really depart from the existing constitutional frameworks and incorporate this idea of nature rights? People were very concerned about this. They were very concerned about their developed model, about the extractivism model, about mining companies, about transnational companies, about water as a commodity, and they thought it was the end of Chile. I mean, you will destroy the country. That was something that I heard even in my house. You will destroy the country. And so I'm thinking, okay, well, you can say, oh, it's just a piece of paper. No, it's a very relevant piece of paper. And then I was thinking, would it be better? And then this question I'm asking you, would it be better to start with some principles? And then we'll start from there. I mean, not to do the whole revolution at once, but just start with, I don't know, intergenerational justice, or this idea of good living. Maybe start from there, and then kind of over time incorporate the other things. And then I'm really skeptical if we can do a different economic system from a neoliberal and extractivist one. Because I don't know. I don't think the Constitution has the tools in order to kind of transform the economic system. I wish it could. It's part of my work. More and more I'm skeptical of it. And just to finish on a good note, if you have any more to know about the Schuylkill River project done by one of my doctoral students, there is this website with English translation, and she has done participatory mapping and an amazing work with Indigenous Pehuenche communities. So thank you so much.
Screen, or I don't need that.
I don't know how you do that. Oh,
you ask me. Okay, good. All right. No, we are back to. That's okay. It's more interesting than the just blue thing. Okay, so thank you, Amaya. This is really fantastic, and in terms of your preach for interdisciplinary work, it's really music to my ears, and within the community of comparative constitutional studies, that's basically has been my agenda for the last 10 years, so it's all fantastic. I think it's been a while since I read a paper, so the paper you sent to us, at least, the initial paper is just 12, 13 pages, and the ratio of ideas per ink there is probably the best I've seen in a while. So it really is thought-provoking. And in the morning, this morning, I sat down to read the paper, and the ideas have been flowing since. So it's been 8 hours and counting. So really fantastic work, and thanks for visiting us and presenting it. And I should also mention that we share some important Canadian connection that I will go back to in the end. So Amaya did her, I believe, LLM at University of Toronto, and then moved on to do a PhD at York University, that other place in Toronto. It's a kind of Yale-Harvard competition in the Canadian context. North of 401, Amaya will know what I'm talking about. It's a highway that separates, and so it's terrific to see you again. So in the spirit of constructive criticism, in an attempt to raise some discussion and perhaps to somehow streamline or sharpen the paper as an academic product, I will offer maybe 4 or 5 thoughts, however half-baked, and then we'll hear from Guillermo. So my comments are more general, and then I'm guessing Guillermo will offer more comments on this specific Chilean context that I know very little about, certainly compared to the two of you. So my first comment is, and I think it is reflected in your presentation, there are essentially at least 2 major themes in this paper, and to me, it was not immediately clear. I'm sure it's clear in your mind, but to me, as a reader, it was not immediately clear what exactly is the main theme. So the first theme is, of course, the right of rivers, and rivers as having legal personality, and all that area that you explored in the first part of your talk. And the second is indigenous knowledge, and to what extent it relates to this entire business of rivers and the right to water, and who owns natural resources more generally. And I think that's an important point that I'll get back to in a minute. And then on top of it, there is the issue of constitutionalization, and to what extent, and you raised it towards the end, to what extent constitutionalism is the right forum or the right path to resolve those 2 challenges. But let's leave the constitutionalization question aside for a second. My first thought was it was not obvious to me what is the main analytical focal point of this particular paper, whether it is rivers and the rights of rivers as part of a general right to nature, and or the rights of indigenous populations in general, the status of indigenous knowledge as supplementary to scientific knowledge. And I wasn't entirely clear how the two, again, I'm 100% sure in your mind the connection is obvious, but in the paper it's not. So it would appear that you move from one theme to another, and I highlighted, I can send it to you later, I highlighted some parts of the paper where, and in one paragraph you talk about that theme, and then you move sort of seamlessly to the second paragraph and you talk about the other. So that's more sort of a analytical framework issue. The second issue I want to raise is that's focusing now just on the first theme of courts' rulings or constitutional provisions recognizing rivers as bearers of rights and or as having legal personality. So as you rightly point out, this is a trend, and Latin America has taken the lead. But you, of course, correctly suggest that this is not confined to Latin America, and you mention, in India, and we are talking the Ganges and so serious rivers, major rivers. It even was followed up in Bangladesh and in New Zealand, as you mentioned, and most recently there are at least 12 jurisdictions now that have recognized the rights of rivers, in some of which are in Latin America, but not all of them. And most recently, there is even Spain, and there is a piece of legislation in Spain that recognizes that Mar Menor, maybe, it's in the Mediterranean near Murcia and to the southeast. I think it's a sort of it's sort of part of the Mediterranean Ocean, part a lake. It's hard to describe, and there is now a serious new piece of legislation as of November 22 that recognizes the rights of that lagoon, and so it's a common trend, and in that respect, of course, the obvious questions for every legal scholar is, number one, who speaks for rivers, who speaks for nature, who speaks for animals, the agency problem that is easy to identify and resolve when we talk about human beings, but it's very difficult to resolve when we talk about the rights to nature, and it's a well-known problem. The second, maybe let's confine that to two. The second is, of course, what happens in situations where rivers cross jurisdictions. And so it's easy to talk about all those relatively small rivers that maybe are confined within the territory of one country, but it's much more difficult to talk about, the Nile that you mentioned, that goes through, 3 or 4 countries at least, or the Danube River or the Rhine in Europe that crisscross the entire Europe with 10 or 12 countries. And so it's not entirely clear to what extent a country X can do something. And I think there is some serious international law governing rivers, and it ought to be incorporated into the discussion, because there is this assumption here that those rivers are contained within a single national territory, and in many cases, at least the big rivers, it's not like that. So perhaps that's something that ought to be incorporated somehow into the discussion. The second point, or third, who counts? The third point is what I called in an article from 2019, I believe, or 2020, I can't remember, spatial statism. So the notion that when it comes to the governance of territory, constitutions are very much a Westphalian statist project that aims to create and consolidate and solidify the status of state governance over the territory. And in that respect, it could be, the most remote inch of the territory is as much Chile as the Central Plaza in Santiago. And so that is the statist project, state building and state outreach and all that stuff. And so when it comes to territory, perhaps even more than anything else, the state is very adamant about maintaining its control and supremacy, normative and practical. It's a matter of, borders and control and all that stuff. So it's very much like Jim Scott's famous, seeing like a state project, where the entire territory, yes, it came up earlier.
I was thinking about it as it was being taught.
I can tell that you attended one of my, you were enrolled in one of my courses. No, it's totally you. That it's very much seeing like a state project, a Westphalian project, if you will, that is predicated on this notion of the state as the center of the constitutional imagination, territory-wise. And if you think about it, it's very similar to problems that I've written about recently of cities and how cities lack recognition and this entire urban-rural divide. It's a new phenomenon that doesn't it's off the grid of the statist understanding of the territory. And in that respect, the problems you identify, and in your paper, it didn't come up in your presentation, but in the paper you very much say that this statist control of water is a colonial project. And it's a word that you use a lot. And I want to suggest that is at least as much a statist project as it is a colonial project. So it wasn't entirely clear what makes it colonial and not statist. I guess that's the bottom line of my point. The third or fourth or whatever issue, and just that goes to tell you how my thoughts were flowing in no particular order when I thought about this. I wish we could comment on papers like that every day. It's the essence of academic scholarship what you did here. So, and again along the lines of whether this is a statist or a colonialist project. So, as you know full well, there is this doctrine in international law of permanent sovereignty over natural resources. And the idea was, and it evolved in the 50s, 60s, in a pretty much straightforward post-colonial impulse. And the idea was that all those France and England and Spain and Germany and the Netherlands of Portugal of the world essentially stole consistently, robbed those 100 countries in the global south, colonized territories of the natural resources consistently all the way from the 15th, 16th century all the way to the mid-20th century. And so the idea of permanent sovereignty of the state over the natural resources within its boundaries emerged as a counter-colonial legal means to protect so basically to prevent, let's latch on France now, to prevent I just had a quarrel with a French scholar, so let's bash France now. To prevent France from continuing to steal stuff from Africa constantly, but of course that applies to any other major colonial superpower in Europe. So then the question is, to what extent, so I guess theoretically speaking, the main doctrine here that governs, it's not just water, it's natural resources more generally, is a doctrine that was designed to protect state autonomy and sovereignty. And against it, you propose here another, normatively attractive impulse that the natural resources ultimately belong to their original quote-unquote owners. And so we have some tension between the notion of state ownership as a counter-colonial measure that is widely accepted in international law, as opposed to indigenous ownership of resources as a counter-statist measure that I take it you advance. And so we need to somehow reconcile between the two concepts and in an interesting way. And related to that is another idea apropos global justice, the idea that ultimately indigenous, statist, regional, what have you, the initial allotment of natural resources is completely random. So it's not, the fact that Saudi Arabia is a rich country, or Qatar or United Arab Emirates, are all very rich countries, and can buy the World Cup and can buy the Louvre and can buy all those things is essentially a complete matter of fluke. Because they sit on a huge natural resource that the rest of the world needs, but it's not like they developed it. It's not intellectual property, so to speak. It just happens to be there. And so in some respect, the fundamental questions of global justice / global injustice may well apply to the question of indigenous ownership of those natural resources that are, if all said and done, or at least have some serious lottery element to them. So now the question is, who is the real guardian or custodian of those natural resources? But it's not an easy, the answers here are not going to be easy. And perhaps ultimately, the real matrix here is some sort of global redistribution of resources that talks about water. And by the way, as you know very well, Canada sits on 9 or 10% of the world's fresh water. That's right, it's a single country. It's by complete fluke. So it's not that you get it. It's not that I'm latching here on Saudi Arabia. It's my home country as well. And Sudan has a fraction of the world's water. So it's not like it's not the Chilean state versus indigenous populations. It's the problem of global distribution of natural resources is deeper than that. I guess that's what I'm trying to suggest. Let me now turn to maybe my final two points, and I want to let Guillermo speak. So towards the end of your talk, you delved a bit into the constitutional element of it all. In here, the obvious question to me was to what extent the constitutional sphere and all those detailed constitutional provisions that you put on the slide and in your paper even more, maybe 6 or 8 or 10 different provisions that address indigenous people's rights in the context of nature. So the obvious question was, it was not entirely clear to me to what extent constitutionalism and constitutionalizing these matters is the most effective way of addressing the problem you identify. I'm not going to go into what comes first, institutions or societal or ideational change. I will say that, again, Canada, that is a world leader in protecting how the way we call them in Canada, Aboriginal or First Nations, Aboriginal people's rights. All of this is based on a single, rather generic constitutional provision in the Constitution Act 1982, Section 35. And 98% of the progressive agenda is done through constitutional jurisprudence by courts and not through constitutionalizing all of it into great detail. It's more sort of a call for the courts to interpret things in a more generous and indigenous-looking way and incorporating all those local traditions of knowledge and stuff. So an obvious question is, to what extent the constitutionalization craze, if you will, or in Latin America, is the right way to go when protecting those things. And finally, my last point, and again, drawing on Canadian constitutional jurisprudence, perhaps a middle, a sort of compromise in a way between those two ends, is what Canadian constitutional jurisprudence and the Supreme Court of Canada have called the duty to consult. And the idea here is not so much that you constitutionalize all those unqualified rights to water, to the environment, to all those things and rivers and whatnot, but rather you simply establish a notion that the state, the government, has a duty to consult with indigenous communities and indigenous populations regarding any measure concerning natural resources, including rivers, within the territory that is widely recognized as historically controlled or occupied by indigenous populations. And interestingly enough, in two leading decisions of the Supreme Court of Canada, one is Haida Nation from 2004, and the other Taku River, that's a Taku River from 2005. The Supreme Court of Canada established this duty to consult principle that has since become the norm in addressing issues of the nature you raise in the paper. And so the issue is, the point is perhaps to establish some sort of, if you will, joint governance over those natural resources in a way that is mutually respectful, in the indigenous voice is heard in making those decisions, rather than going, and here I'm just quoting or relying on your really fascinating talk the other day at the Global Summit on why the constitutional reform in Chile failed. And essentially your point was, you didn't say it, but my words, you said, there was too much Aboriginal or indigenous rights here all over the place, and the legal establishment essentially turned against it. And you just said it, you're demolishing our country and all that stuff. Maybe instead of going in such a blatant omnibus way, perhaps the all-encompassing way, maybe the right move would be, again, to establish something like a duty to consult, whereby all government institutions and authorities, including ministries and stuff, just must consult with Aboriginal or indigenous populations, including taking into account the indigenous knowledge that you refer to in making decisions concerning nature and rivers. Thank you.
Hello, everyone. Thank you very much for this invitation. And I jumped on this vote in the last minute, so I really hope your expectations are not too high. First of all, it's an honor to share the panel with Professor Alvez and Professor Hirschel. It has been a pleasure to share these days with Professor Alvez because I have been able to witness her human and professional quality, something I really knew since the days of the Constitutional Convention, where I had the honor to share sometimes in the commission chaired by her, which was, between us, the best commission in the convention. And I'm very glad to be able to talk in Chilean during these days. The Chilean Spanish is great, and we have been talking like that all these days. I think the paper of Professor Alvez is fascinating for several reasons. In the first place, the water problem is one of the most serious today in Chile, especially when you think that in Chile we have many areas where the people have to choose if they take a shower, cook, or use the bathroom. And it's quite interesting how the problem of rivers and waters in Chile is presented in the paper. In addition, I think the approach is very innovative and comes to refresh a lot of discussion regarding the right waters and rivers that it's pretty old, and it's based in some assumptions that are not happen in the reality. I think, and I want I agree with the point that Professor Hirschel made before, that this paper, for us who study comparative constitutional law, it's an excellent example of how to build a multidisciplinary approach to a complex problem that includes, among other dimensions, that of constitutional law. However, I would like to enumerate some of the tensions I believe that are implicit in the paper. I'm sure that Professor Alvez is aware of most of these things because we have been discussing them in the last few days. Firstly, and in a more general level, the contrast between neoliberalism and the new Latin American constitutionalism as the two poles or axes where the former, the neoliberal order, depredates the environment, while the later, the project of Latin American constitutionalism, takes care of it, seems to be a bit problematic. No one can doubt that extractivism and environmental depredation of neoliberalism has been grown in the recent decades, but I think the ecological crisis far exceeds the category of neoliberalism. The environmental issue is much deeper, and it's at the basis of the assumption of practically modern era. It was Descartes who said that we should become masters and possessors of nature. So if the idea of being the masters of nature, of dominating the nature completely, is at the basis of the modernity, the nation state, which is one of the most radical expressions of that modernity, is necessarily influenced by this idea of master and possessor of the nature. Therefore, focusing the environmental discussion, the water problem, only on the responsibility of the neoliberal order can make us blind to the depth of the ecological problem and make us forget that perhaps the region of issues such as those related with water in Chile is in the assumptions that sustain the national state rather than only in neoliberalism. Environmental disasters and the lack of care for the rivers and water have not been exclusive patrimony of neoliberal countries. And for example, Bolivia of Evo Morales is a huge example of this. They are in the influence of the new Latin American constitutionalism, and they have pretty big problems of contamination and pollution and all that stuff. And this is linked to a second idea I would like to mention. Despite the virtues and the criticisms Professor Alvez points out in the paper, and which I mostly share, the constitutional orders inspired by the new Latin American constitutionalism also have many problems in dealing with the dynamics of the modern nation state that render indigenous groups invisible. While Chile has problems with disregard for indigenous peoples in multiple dimensions, countries as Bolivia or Ecuador, the most representative countries of the new Latin American constitutionalism, also have similar problems in other areas that, while not reflecting neoliberalism, show huge difficulties in construct horizontal relations between the state and indigenous people. Despite the constant discourses favoring indigenous people, there is a permanent tension in these countries between the rhetoric in favor of the indigenous people and the political practice in the nation-state context. It's true that on paper these countries offer projects that appear to be counter-hegemonic. However, they sometimes tend to replicate the very logics they seek to overcome or combat. Thus, for example, the logic of horizontal dialogue proposed by the plurinational projects of Bolivia and Ecuador between ancestral knowledge and the dynamic of the nation-state usually ends in the imposition of the nation-states on indigenous people, in the submission of indigenous logic to modern categories. In fact, the idea of indigenous constitutionalism, of bringing indigenous people into the modern constitutional dynamic, I think it's one of the main issues of this problem. At the end of the day, the dialogue on equal terms between the old and the new has many obstacles. The nation-state and its enormous machine almost always end up imposing itself. And here, I think, appears another tension between, on the one hand, wanting to overcome the standardized, the homogenized logic of the nation-state action on the diverse territories, and on the other hand, enlarging the state in multiple areas of ordinary life. The same state that was established on the assumption of men's dominance on nature. I think this logic forgets that the homogenizing vocation of the state in the territory is often unable to consider the social differences, the diversity, the heterogeneity that also exist even within the same indigenous people. And this is a problem that, at least in Chile, exists not only concerning the indigenous people, but also concerning the different regions and local governments. And on the other hand, there is also another problem at the base of the indigenous project of the new Latin American constitutionalism, is that on many occasions the intellectuals' approach of people that defends plurinationality projects reflects an attempt to return to an idealized past that does not exist, to see the indigenous people as the noble savage. I think sometimes there is a sort of essentialist vision of indigenous people. We talked about this with Amaya yesterday, which tends to forget that there was a pretty big movement of mestizaje in Latin America, in many Latin American countries, and that the classification between indigenous people and non-indigenous people is not so clear and is more complex than it seems. Many times it's the same indigenous people themselves who refuse to be understood as we understood them. The number of votes against the Chilean constitutional proposal on places with a high indigenous population is a proof of this. Or, for example, one survey that came up after the Chilean referendum showed that 12% of Mapuche people supports the plurinational project of the Constitutional Convention. So maybe there is a distance between the institutional arrangements that we are thinking for indigenous people and what indigenous people want. And I would like to show these tensions between the dynamic of the nation states and indigenous people with a brief example from the Bolivian Constitution. The preamble of the Bolivian Constitution established that we, the Bolivian people of plural composition from the depths of history inspired by the struggle of the past, by the anti-colonial indigenous uprising, we left the colonial, republican, and neoliberal state in the past. We take on the historic challenge of collectively constructing an unified social state of plurinational communitarian law. When you read this and you think in the beauty of those words, you don't think that when you see another constitutional norms or you see the political practice, the judicial practice of these problems, the situation is quite different than the rhetoric and the discourse. If we analyze, for example, the functioning of legal pluralism, the distance between, in Bolivia, the distance, and in Ecuador it happens the same, the distance between the discourse and the reality is brutal. The constitution and the law in Bolivia set many limits to the functioning of indigenous justice system. For example, the Bolivia's jurisdictional demarcation law established the framework of legal pluralism and has been object of intense criticism because some authors, for example, have pointed out that this law goes against any idea of decolonization. Other authors has been said that it's like a regulatory folklore with no subject matter to deal with. And an example of this is the Article 10 of that law that states that the indigenous jurisdiction hears matters or conflict that historically and traditionally have been heard under their own rules, procedures, and knowledge in accordance with their self-determination. When you hear that article, you see, you think that it's pretty respectful of the reality of the indigenous people. However, the same norm established multiple matters that are excluded from the indigenous justice, such as murders, homicides, corruption, labor law, property law, and this has been pretty criticized mainly because the issues that are historically and traditionally being resolved by indigenous people are excluded from the indigenous justice. And that happens in a country as Bolivia that has the most robust agenda in indigenous people. And when you see these limits in legal pluralism and in other topics in these countries that represent the new Latin American constitutionalism, it's possible to notice that Bolivia and Ecuador, for example, have limitations to legal pluralism that are not so different from the boundaries of any other country with legal pluralism that is not part of this new Latin American constitutionalism. So it seems that even in countries with this robust indigenous agenda, such as Bolivia and Ecuador, it's challenging to achieve the idea of the horizontal dialogue between the cosmovisions of the state and the cosmovisions of the natives people. And thirdly, and by way of closing, I believe it's essential to be aware too of the limitations of the constitutions in resolving these profound tensions between the state and the native people, or between the state and the nature. On the one hand, constitutions cannot handle all the problems since they are limited tools, and the main goal is to create a framework for political power. And on the other hand, constitution cannot modify from one day to the following social realities that are firmly rooted in society. I believe that having too much faith in constitutions as tools for social change is one of the problems of Latin American constitutionalism, and was one of the problems in the Constitutional Convention. There is so much talk about the Ecuadorian constitution, but we must remember that Ecuador has one of the highest rates of constitutional replacement in Latin America, and the highest amount of interbranch conflicts in the region. There is so much talk about the Bolivian constitution, but we forget to see how much of what appears in the constitution in the paper has practical applicability. What is it actual the capacity to modify reality, or if it's even the promoters of the indigenous agenda themselves build policies aligned with plurinational ideal. For example, it has been proved that the inconsistencies, there is some evidence on this, that the inconsistencies of Evo Morales in this regard are well known. He is one of the main defenders of the indigenous agenda, but he has promoted policies that threaten the indigenous people. Today, I think the nation state and its logic is predominant, especially after a pandemic that gave new relevance to borders and the power of a state to control movements. And this also complicates and complex the horizontal dialogue between people, the mixing of knowledge, and the possibility of building institutional solutions that respond to the diverse and flexible context. And finally, I'm very grateful to Amaya for this work, and I'm also thankful for Professor Hirschel's reflections, and I believe that being able to talk about this type of phenomenon in this context is very important and necessary, so thank you very much.
No, I think we just have a couple of minutes, so I rather gather if there are any questions or comments or concerns. Because we will talk, right, after. We will see. Yeah. So, I don't know, who has a question, a comment, a critique? Shall we gather kind of 2 or 3 and then respond, or what? Okay, I don't want to change the rules.
Yeah, just ask question. We'll have 3 questions.
Oh, no, I have a question for Amaya. Hi, Amaya. I'm Pablo.
Hola,
I come
Pablo.
from Mapu, the Mapuche territory, in what today is called southern Chile. So I would like to ask you some reflection. How, from your point of view, you reflect about the rejection of this draft by many Mapuche community in southern Chile? And another question is, what do you think about the current response by the body government against the Mapuche movement in southern Chile? Yeah. Thank you.
I think this is anyway. My question is sort of in the who speaks for the rivers category, but I think it's a little different. And that is, maybe because I'm used to thinking about this in the context of Latin America, and then Ron put on the table the Danube and various other rivers, and so I wondered, right, in your paper they're pretty linked, and I wondered if you can think of a project of rights of nature that isn't grounded in indigenous culture and the value that indigenous cultures place on things like rivers and waters and other features of the natural world.
Well, thanks for the presentation. So I guess it doesn't surprise me that there's so much novelty in Latin Question I have, whenever I think about rights of nature, rights of water, it's always so abstract and confusing how that would actually be litigated and what sort of cases would come up. And I just wonder, given that, in some ways you had to give yourself over to river science and other questions of natural resources to understand the various implications of these provisions that were in the Constitution. I'm just curious to what degree that went on with other members of the Constituent Assembly and how much they thought about how this would actually be litigated, how the rights of nature would be litigated. Because I think most people really have no idea what the implications would be. And of course, it's so important if you're going to adopt these provisions.
You want to answer those three and then we can do another batch?
Yes, thank you so much. So, Pablo, I think with the rejection data, I think this is one of the flaws we have in the system. We really don't have good data, and I think that, I'm not sure, but I think you were alluding to the one that came up in December, right? In December, Guillermo? The CEP survey, yeah. The thing is, in Chile, we don't have public surveys. In general, there are private, done by some institutions. There are, who I will say in general, I'm not talking about this one, have some interest in showing like a picture of it. If you take the official electoral information in Rapa Nui, the project, the draft was like by far approved. So I don't think you can generalize the claim for all indigenous peoples in Chile. But you know what, Pablo, I was thinking, because I know several communities. I've been a lawyer for several Mapuche communities in Concepcion, and in a way they distrust the state. I mean, it's not that they didn't like this draft. In general, I think the problem, the actual conflict has made so many people be so skeptical of what the state of Chile can really do in favor of them. So I guess many people didn't vote in favor because they didn't trust what was being offered to them. And this is just a hint. I would love to do some research on this. But I know many people that I'm close to that didn't vote in favor of it because they didn't believe this was even possible, or it was something the state of Chile would really put forward. And in terms of the conflict, this is more contingent, political. I think not only this government, I think all the previous government had dealt very badly with this issue. I mean, we haven't been able as a country to debate the deep political roots, political, economical, social, environmental roots of the conflict. And now we know there are even like organized crime as a deep problem, like running among all those lines. So I do think we have a big debt, a huge debt of acknowledging a political deep problem that we haven't been able to address in a political, in a governmental, in a legal, in a constitutional way. I think it's so much more deeper, the invisibility of the indigenous people, of the Mapuche people. So I don't think this government this presidency has been especially bad. I think all of them have been very bad. And the only time we had some hope was with the report on verdad, or truth and new treatment. I mean, those 900 pages, I think, are much closer to what really happened on the ground. But what happened after the report? Nothing. So there you go. We don't have a public policy on indigenous issues that is worth now. It's worth it, in the terms of serious. Daniel, who speaks for the rivers? That's, I was telling the PhD students yesterday that I think this is a political problem because in all legal terms, it's solved. It will see who speaks for the society, the CEO. Who speaks for the Coca-Cola company, the CEO. I mean, from a legal perspective, it's solved 200 years ago about like representation of legal entities. The thing is, there have three solutions. There have been three solutions. Public action. You can set up a public action so everybody who has an interest can come forward. Guardians of natural elements, and normally will be the population, the community living next to it, indigenous people, Afro-descendant, poor communities. Or there has been developed in the last couple of years an ombudsman, but a nature ombudsman. So like particular for those rights. So those are the three legal possibilities. But I think the real problem is a political problem. Who will you give the power to represent nature, and what interest you need to have? Because at the end of the day, I mean, like everyone can have an interest in nature, even those who want to like have some business with it, right? And yeah, I like this idea of Latin America being a laboratory. I don't know. Yeah, it's interesting, and you know what? There is this very interesting project. Chile is not part of it, but as a regional human rights project, Argentina is part of it. What they develop is specifically on some socioeconomic and environmental rights and cultural rights. They set up a system in which they will have parameters to see if you are advancing or not those rights. It's not like this flawed thing that the government will say, yeah, of course we're doing whatever we can, because that's the normal response in terms of social rights. They develop, like, I don't know, in the human right to, I think the housing rights is something like 90 parameters that you will need to say how much money you're giving for social housing, how much, and I think the first report is about Argentina. And this professor from University of Buenos Aires was writing about it. And they have this whole project of putting like strict parameters for advancing some rights. So in terms of the human right to water and sanitation, there are very strict parameters. 100 liters per person per day, no more than half an hour waiting in line, no more than X kilometers from the source of water. So you can think of a way in which you can kind of address those big rights and put it down on paper. Yeah, yeah. So that project, I can send you information. Chile is not part of it. Chile, I mean, in our constitution, social rights are really weak, but Argentina has done a great job on that. And I look at Ariel and Daniel, who knows much better about it. Okay. Okay. There you go. Oh. Don't worry, I will.
Oh, it's for the recording. Oh, it's for the recording? Yeah, sure. Sounds good. So I'd like to make a callback to the head nod that I gave Ron about Jim Scott's book, Seeing Like a State. Specifically, one of the themes that I was reflecting on from that book is this idea that the scientific knowledge that your PhD student, for instance, is engaging with is the fact that there is this metis, this practicable knowledge, practical skills and acquired intelligence in responding to a constantly changing natural environment, right? And I think that your paper, or the project at large, the way it comes off upon first impression is very complementary to the broader theme of Jim Scott's book in the sense that it's a complementary call for creating human institutions that are open to improvisation and founded on a very humble premise that we have incomplete knowledge, both about the environment and other political issues writ large. So in terms of how you might be able to link the two very complex topics of ancestral knowledge and environmental protection, or really just ecological respect, is to reflect a little bit more on the broader theme about how scientific knowledge is not in of itself a colonial or a statist project, but only when it assumes an imperial form, when it actually goes about denying the legitimacy and the value of that specialized practical knowledge and metis. And I think that might be a really interesting way to perhaps frame the conclusion.
Yeah. Oh, that's very helpful. Thank you.
Thank you. That was really, really wonderful. This is a kind of a paranoid follow-up to the last question, is because I get hugely anxious when ancestral knowledge hits state and market institutions. So the story about the musical instruments just made me think of a South African story. Okay, there's a plant called hudia, which is, indigenous people have used it for who knows how long as appetite suppressant when they went on long hunts. So some, like 15, 20 years ago, some pharmaceutical got hold of the formula, patented it, and made quite a lot of money. And so I kind of think, so there's the supranational is not just international human rights law. It's also the market, it's also international patent, intellectual property. So I'm just also nervous when one brings these things into representation and makes them available for certain audiences, they get available for other kinds of capture. So that musical instrument, if they find out how it works.
Kultrun. Yeah.
So I have two connected question comments. One, when I think about the right of nature, I'm thinking that it's nothing new of a new human rights with a different name. That at the end we create a normative framework, we create somebody who can argue on behalf of that right, and then we send the claim to the courts to decide the complexities of the things over there. So I'm trying to understand what is new about granting rights to nature. And I don't see that. But my main concern is that by granting rights to nature, we may be detracting rights from indigenous people, from their own rights to decide how to use the natural resources in their own territory. Because now anybody or everybody or the ombudsman or whomever can claim the rights of nature being harmed by the use given by the indigenous people. So how do you reconcile these potential tensions?
No, I'll keep it for later.
Okay. Thank you so much. So, yeah, with the sin like a state, I do think it's interesting. I guess this is a draft, it's not a final paper, so I do think there are different kind of, and Ran's comments make me think of that. There are different takes that you could think. One thing will be the scientific knowledge and ancestral knowledge and how you deal with both, not necessarily in a constitutional setting. And the other one will be, and I've never thought that indigenous will be the only one kind of having sovereignty over those territories. I was just thinking, can we reconcile different views on the same river? I mean, can we just think of working together, and maybe you are a citizen, a Chilean, a farmer, and you're an indigenous community. Can we think of a way in which those different perspectives could talk to each other? And of course, in tensions among rights, you need to deal with it and go to a methodology that can make sense of it. I mean, you can't really just put one on top of the other. And this is one of the problems with water rights, because normally they will do a hierarchy, and then number one will be the human right to water and sanitation. But then you come up with this idea, but if you don't put ecosystem balance, you won't have water for sanitation or to drink. So ecosystem balance will be, or rights of nature might be at the same level as the human right to water and sanitation. That's a debate we're having. So in terms of hierarchy, but also of tensions, I haven't thought of getting rid of scientific knowledge or the other, just how to combine both. Can we talk to each other? And then, of course, there'll be tensions and how you deal with those tensions. And you are so right. That's the problem, because when you want to grasp ancestral knowledge, it's because you want to recognize it and protect it at the same time. But there is a way in which we downsee this. For example, if you go to Chile, I hope you go to Chile, in southern Chile, everything touristic has a Mapuche name. And I've always thought, if you're using Mapuche names, you should kind of pay a tax for it, or at least ask for permission. Because, Cultrún is a very famous wine. And I think it's a sort of disrespect way of using a name of like a sacred instrument for a wine. Maybe it's a great it's a great wine and I'm happy. But even maybe ask if you want to name it Kulturn. Because I don't think if you will call it Kalis or other names or religious names, I think it's a way of disrespect. So I guess intellectual property is a big issue, and it's also protection. I mean, there's so much work to do. I mean, you said that story. I know many stories about plants being used by pharmaceuticals and use Mapuche and other indigenous people knowledge in favor of those pharmaceuticals and not the indigenous people themselves. And of course, I think, Ariel, you go back to something that is really interesting. And if in any of these knowledges are there limits, and I guess the limits could be human rights standards, but then we go back to that debate, okay, but human rights as in general are very Western, right, are imposed. When we talk about ancestral knowledge or indigenous people's knowledge, can we kind of put a limit? And our proposal had human rights as the limit on a debate, on an open debate, right? So you talk about, I mean, in Rapa Nui there was a big case recently because there was a criminal limitation under Rapa Nui law for rape, and that was very bad because in Rapa Nui women went against the law, saying we don't want this. We want the full human rights paradigm being imposed. We don't want rapists to, serve less time in jail just because they think our culture is barbaric. And they won before the Constitutional Court, 9-1, which is great. And they put those sections of the law away because of human rights standards. So I guess you need to work, I think you said it, in a non-essentialist way because indigenous people develop over time. We have this idea in Chile, if you're indigenous, you need to run half naked through the prairies. But this is a way in which you diminish the very concept and there are cultures that could develop, of course. Okay, thank you so much.
I just want to thank you all, and I want to especially thank our speaker. The Rapport Center is doing quite a lot of programming this semester on environmental and climate justice. So look on our website. We generally have a seminar every Monday or every second Monday at 4 o'clock. And I also want to thank Cooper and Caroline and Quinn, who do all the logistics and do a very good job of managing up so these events actually happen. So thank you all for coming, and thank you very much to
thank you, guys.
Professor Alvez.